First case on the call this morning is number 121536, Corbett versus County of Lake and City of Highland Park, agenda number 12. Counsel, are you ready? Yes. And are you? You may proceed.
Mr. Chief Justice, members of the court, counsel, good morning. For the record, my name is Peter Higgins. My co-counsel, Lynn Dowd. May it please the court. The issue before the court today, I agree with counsel, is therefore whether the appellate courts have defined riding trail correctly for the past 23 years. If this interpretation is correct, then the lower court's decision in this case should be allowed to stand. It would be absurd to read this trail, to read it one word in isolation, that it's a riding trail that doesn't apply to scenic wooded areas.
What does riding mean then? Is there a limiting language to define riding?
There's no language to define riding, but if you read the entire statute together in peri materia, riding can be bicycle riding. Specifically say riding, but we're talking about the different types of areas. Where do you draw the line?
It doesn't make any difference. It's how you use it doesn't make any difference, whether you walk or ride.
I would agree with that, Your Honor.
Then the word riding trail means nothing, riding.
The word riding trail applies, but again, the focus, I believe, from the legislature is on the property itself and the surrounding area. That's also what the courts have interpreted as.
So location determines immunity.
Yes, yes.
Well, what if there's some of both? In other words, it goes through some undeveloped primitive area, but it also goes through some developed area. Does that affect your analysis?
That was a question from the Mull case and also addressed in Corbett in the lower court. Draw the line.
I understand your argument relative to in peri materia, but what about the other side of that coin, where we sometimes say when a legislature says something in one section of the statute making limitations and then in another section does not? How do you respond to that?
Well, Your Honor, I'm going by what the case law has said. They have said that you look at both sections together. You can't take the word riding in isolation and just say, well, that means it's for bicycles in this area. You have to take the whole section of the Act of 3107 as a whole. That's been repeated throughout all the cases. Really what we're talking about here, Your Honor, I think the bottom line, including this case, there have been 7 cases interpreting trail. The court below did nothing wrong here. It simply followed precedent. 3107 is good law. It makes sense. It shouldn't be changed. It was truly an honor to address you this morning. Thank you very much for your time.
Thank you, Mr. Higgins. Case number 121536, Corbett versus City of Highland Park and County of Lake, will be taken under advisement as agenda number 12. Mr. Atkins, Mr. Higgins, thank you for your arguments this morning. You are excused with our thanks.